Mouth is full.
Yeah, right. Well, I'm not going to say much. You'll say, well, that's a first. She doesn't
Enjoy
say
your lunch.
much.
Don't worry.
So we live. We're live. Whoops.
Whoops.
Well, welcome back, folks. This is House Corrections and Institutions. It is Thursday, the 26th. We're beginning our afternoon meeting, and we are a little late. I got tied up. I thought we could spend some time with the judiciary. And we have Judge Zone with us, who is our Chief Superior Judge, to go through the front end of the criminal justice system so that folks can really start understanding how people come within, get to the correctional system, become incarcerated or don't become incarcerated, but may be under correction supervision in terms of probation. But it's really law enforcement. There's a charge, goes into a court situation, judiciary, a charge and an arraignment. And then from there, it can go in a lot of different directions. And I thought it would really be good to have the judge come in and give us what that process is. And for the committee members to ask questions. And I think, of course, one of the questions that I'm sure we'll ask as a committee, how does bed count influence decisions that the Judiciary Committee makes? So we're just a Judiciary Committee paying any attention to the bed counts of our incarcerated facilities and if there's openings, empty beds or not. But I really want folks to understand how people come into the correctional system. I think there's a thinking out there that DOC has the control of everyone coming into their system. They make those decisions. And there's a real front end process to that. So Judge Zone, welcome.
Thank you.
And we have a whole new Corrections and Institutions Committee. And maybe it would be good for us to go around and introduce ourselves. Yes, Chip?
Yep. Chip Troiano. I represent Hardwick, Stannard, and Walden, and I'm the vice chair of this committee. Welcome, Judge. Good to see you.
How are you, Judge? Connor Casey from Montpelier here. Great to see you.
Hello, how you doing, Judge? Gina Galfetti, Barrytown, and a little bit of Williamstown.
Marcy Bennington and a little portion of
John Harrison, Weathersfield, Cavendish, Baltimore.
Michael Rush, Highgate, Franklin, Richford, and Berkshire.
Hi, I'm Troy Hendrick. I represent Burlington.
Michelle Boslin, Westminster, Rockingham, and Brookline.
Well, good afternoon, Your Honor. Eric McGuire, Rutland City.
Welcome, Judge. Tristan Roberts, representative from Halifax, as well as Whitingham and Wilmington, clerk of this committee.
Thank you. So for the record, I am Tom Zone. I am the Chief Superior Judge. And some of your first questions might be, what does the Chief Superior Judge do? In other words, what is my role in the judiciary? I was appointed 16 years ago. I've been on the bench. And in November of 2001, I took over from Brian Grierson, who was at the time retiring as the Chief Superior Judge. And the Chief Superior Judge has administrative responsibilities over the trial courts with the trial judges. You'll also hear oftentimes the name Terry Corsells. Terry is the court administrator, and Terry is staffing and buildings and things. And Terry and I work together to make sure that the judiciary, if you will, runs as smoothly as it can. If there's ever questions that you have about our operations, you can let one of us know and we'll be happy. If we don't have the answer, to get it for you. Today, when I got the request to come over, I understood, as the chair indicated, that your request was to get an understanding. What I wanted to do was be clear that falls asleep on the objective that I have here is to provide a general overview of the criminal division process. And I want to highlight that word general, because this is not the end all of, oh, this is the process, this is everything that can happen. When you see a couple flow charts that I have had put together, what you'll see is that there's I could put a bunch of other arrows at different times, at different bunch of times. I think what really would be helpful for today is just to give the basics. And if you have any questions or concerns, don't hesitate to let me know either during our talk, or I have my email address in the presentation at the end. Don't hesitate to email me or stop me when you see me here in the building with any questions. Some terms that we're going to come they're going to come up today. One is ROR, this acronym. It means release on recognizance. That is when someone goes to court and we say, okay, you just been charged, show up when you're supposed to. You don't sign anything, no conditions of release. And that's COR, conditions of release. We'll talk about that in greater detail. But conditions of release are conditions designed to mitigate the risk of flight from prosecution, as well as to provide for public safety. HWOB is a term you'll see a lot, and that's hold without bail. That's when someone is held and they are not able to post bail for their release from the correctional facility. They are held until there's a different order by the judge and they are released. And we hear this term information. In Vermont, an information is the charging document. If you watch Law and Order, you hear that term indictment. The grand jury returns an indictment. In Vermont, we have grand jury potential. We have indictments that can be returned, but we are a state that allows charges to go forward on an information signed under the oath of office by the prosecutor. They don't have to go to a grand jury for charges. They just sign a piece of paper supported by affidavit, and then the judge will determine whether or not that charge that has been brought in the information has probable cause to be able to proceed forward. So let's talk about this arrest without a warrant. We hear so often, well, somebody got arrested. Well, how does that work? Under Vermont law, we have what's called Rule of Criminal Procedure 3. And I will acknowledge I debated, you want to put all these rules in? I went, no, we don't need them. I will tell you, trust me on this. There's a called Rule 3. And Rule 3 talks about the authority of law enforcement officers to arrest someone without a warrant. And there are times they can do it, and there's times and how they do it. Sometimes they can make a custodial arrest, in other words, take the person into custody. Sometimes they have to give a citation. A citation is an invitation to court, is what we used to call that. And I was, by way of full disclosure, prior to finishing law school, I was a police officer in Woodstock, Vermont. And so we used to always say the citation was the invitation to court that we hope people show up on. But what can happen is someone can be arrested. For instance, someone is walking down Main Street in Montpelier, they take a rock, they break a window. The police officer didn't see that happen. The police officer gets a call, comes up, talks to a witness, goes up to the person and says, did you break that window? Let's say it's a $50 window, not too much. The officer would most likely take them and give them what's called a citation into court. And that would be a citation with no conditions of release. In other words, they give the citation and say, you are going to have to show up on this date. And the date will be down the road. And then what the officer would do is prepare paperwork and send that on to the state's attorney for filing the information with the court. There's also the potential, though, for different types of cases. There's the type of case where in the middle of the night, let's say there's a domestic assault. And a man is arrested, for instance, in a domestic assault. The police officer goes to the scene. The police officer makes a custodial arrest. And the police officer takes that individual back and and then calls the judge. And under the law, the officer is allowed to give a citation to that person and get conditions of release. The rules of criminal procedure provide a mechanism where the law enforcement officer talks to the state's attorney, and then the officer calls the judge to say, I have arrested this person. I am seeking conditions of release. Those conditions are issued at night, and they would have a condition that would have the individual appear at court the next day, or the next business day if it was a weekend. And that is done to reasonably assure the appearance and public safety. The decision as to whether to make that custodial arrest and seek conditions lies on the police officer. They don't say, Judge, what do you think I should do? And when an officer asks me that, my response would be, you need to talk to the state's attorney. You tell me what you're seeking. I will determine whether or not it's granted or what the court believes is appropriate. But let's say that the allegations are not, let's say, domestic assault. You could say two brothers fighting. Let's say they're much more serious, where the one brother pulls a gun and beats the other brother with it and says, I'm going to kill you. Well, then the judge has the opportunity to not only look at conditions of release, but under certain very restrictive conditions that we'll talk about, the court can order what's called an HWOB, hold without bail. And the judge can say, you know what, tonight, we're going to hold that person without bail. The judge can also impose conditions of release along with that. We'll talk about that for types of conditions. The judge can also determine that it's not going to be a hold without bail case. Maybe it doesn't meet the criteria for hold without bail, but when the judge gets that call at night, he or she has the opportunity to also consider whether bail will be imposed, and if so, how much. And we'll talk about that, the issues that come up with that also. And then what happens is after that is done, that next morning, the officer provides the paperwork to the state's attorney. The state's attorney prepares the information and supporting affidavits. In our present world, it used to be where they walk the papers over to the court and deliver it, but now they hit the button and it comes to us via Odyssey, our case management system. And then the person is seen the next day. And when they're seen, that's what's called the arraignment. And we'll talk about that in a moment. There's also a situation where, for instance, if you had the brothers fighting and the one brother runs away. And where is he? The police officers can't locate him. Well, the state's attorney may think, well, that man may be on the run. He may be driving up around to Burlington from down in Williamstown. He may be going somewhere else. So we want to pick him up. So what they can do sometimes, and what they will do, is they will, the next day, let's say, they'll file an information with the court. They'll go to the state's attorney, they'll prepare the paperwork, and the state's attorney will prepare the paperwork and ask the judge to issue a warrant. The judge can issue a warrant. That warrant goes into the state system, and then the individual is picked up. When the judge issues that warrant, on its face, the warrant will say whether it's a hold without bail or whether there is a bail that's going to be attached to it. The judge would not issue conditions of release when the judge does that. It's either bail or hold without bail. Now, I did mention that I wasn't going to go too deep into the weeds. There's another option. Let's say this was somebody who was alleged to have stolen a candy bar, but they're trying to get them to come in because they've stolen it a lot. They want to pick them up for retail theft. One of the options judges can also do is issue in the warrant instead of hold without or bail. They can say cite and release. In other words, I would issue a warrant that says, when you pick this person up, I'll take them to jail, give them a citation, and have them come to court. And that way we don't have them go into the custody of the Department of Corrections on some cases that it's appropriate.
So
Yes.
maybe this is a good spot to take a little stop to see if there's any questions, because I know Wayne had a question and then Tristan.
I was just going to ask, on your example of domestic assault where you took them into custodial custody, in all cases, they're detained at least until the judge.
Generally, domestic assault is under our statutes. They are cases where people are taken in for custodial arrests and they have, by statute, need to be seen the next day. So they are cases that conditions are put on and they need to be seen the next day.
So any case where they're just released before that?
If the,
At the discretion?
as a, law enforcement has a discretion as to how to get it, but the statutes do provide that those cases take priority and that generally law enforcement does go with custodial arrests under those circumstances.
And then the person is housed in a correctional facility until the next day or until Monday if it's a weekend to go to court.
Or they're released on conditions. Oftentimes the state will say, yes, it's domestic assault, but judge, there's no risk of flight, and we'll talk about that, and there's no bail, so we just want the following conditions, and the court can impose conditions. Any other questions?
Tristan.
I did have a question. The sort of middle of the night calling the judge situation caught my curiosity around how, police officer picks someone up at 1 a.m., wants to hold them. A judge gets called at that point to get permission to do that until the next day?
Correct. What would happen is the officer, the call would go something like this with me. The officer would call and say, hi, Judge, I picked up somebody for domestic assault. And I had orders out, and our judges generally have orders out in the county for what's called after-hours protocols. And my first question would be, have you prepared your affidavit? The affidavit is going to be submitted to the state. And the second question would be, have you submitted it to the state's attorney and have you had an opportunity to speak with them? And then if the answer to those would be yes, I would say, okay, email me the affidavit and make sure that it's just a number I can call you back at. And then I get their number and I'd write it down and I'd have it on the phone and I'd say, put it in the email. And when I get the affidavit, I would read it. I would then call back and say, what conditions is the state seeking? They would tell me the conditions they're seeking, and based upon that, I would also ask questions. I had information that we had to provide. And we'll talk about the bail statute in a few moments about the factors, but I wanted information, and judges want information about the factors in order to, where is the person going to live? Do they have a prior record, employment, things like that? And we want to get information, and then the judge will say, okay, issue the following conditions, and the officer writes them down as you're there, and the officer then gives them to the defendant.
Do you sleep?
I will tell you that there are some nights you're up quite a bit. We also get search warrant requests in the middle of the night. And thankfully, the rules provide we can do those electronically also. But yes, there's some nights that you're just up and down, up, up, up. If you ask my wife, she would say, yes, he can sleep in the other room.
So for clarification, conditions of release can be set at different times. So they can be set when a person has been arrested. They've gone through that process. The conditions of release are really coming from the state's attorney and the judge in those situations, but it's the law enforcement officer that is explaining those conditions of release to the person that they've picked up.
On any time that it is not done in court after the arraignment, that's correct. It's the law enforcement officer who is providing those conditions to the defendant.
But they're receiving those conditions from the state's attorney and the judge?
The judge, not the state's attorney.
Just
They request, the state's attorney makes a request and the judge makes a decision as to what they will be. And law enforcement has the forms, and so what I would do as a matter of course is have the officer tell me, again, I make my decision, and then when I give the conditions, I would say to the officer, okay, now read me back what you have written down.
Make sure.
To make sure it's there. And I can tell you that there have been also times where I may have done that, and you hang up the phone, and 30 seconds later you go, you know what? I think there should be another condition. And I had picked up the phone and called right back. And that fits into the category of simply because I was unconsciously wrong yesterday does not mean I should be consciously wrong today. So if I think that there's something that should be added, I was someone who would contact them back.
John?
I think we're in the right area now with the red flag possibility.
Yes, definitely when the state's attorney gets involved, because an ERPO is an extreme risk protection order. It's something that is sought by the state's attorney. And so law enforcement can say, I think this case is one that should have that. And the state's attorney has the opportunity to file that. And they also can be filed after hours.
But it still has to go through you.
It has to go through the judge. That's correct. The judge has to determine whether or not the state has established the elements of imminent extreme risk.
Do you have any feel for the frequency that is requested?
I believe there were, I want to say 18 last year, but I don't have that number right in front of me. I think I have it on a PowerPoint in here that I just was, again, a few days ago, and I could get you the actual numbers, but I don't have it off the top of my head.
Curiosity.
So I want to make sure, we still have more questions. I just want to make sure they're at the front end when a person is arrested. Just to be clear, because I know you're going to go through the whole process. Mary and then Connor.
I'm not sure if this will fit into this, but I've had a number of cases heard down in Bennington that you'll hear that the police have arrested someone. We've had a lot of drug activity and people coming in from over the border, either selling. And they've arrested the person only for them to be let out like within an hour. How does that kind of, I guess, fit into what we're talking about here? Because do our laws just not cover this, and this may not be discussion? Are our laws permitting that? Because some of these folks have been time and time again, they're habitual sellers of the drug. They're not, someone that is being approached to buy it. It's the actual sellers. So would a state's attorney or you as a judge say, yeah, they're released without conditions?
without conditions.
No.
On something like that, I would not envision that without conditions, but in a little bit, we will talk about the law that the judge has to apply. And I think it may be very helpful in that particular type of situation.
Because, what we hear it all the time is, and even from our police officers, we're doing our job with what's happening at the time, but then they're out, and it's like, it's almost we become a laughing stock because people are saying, I can't hold on this and that, and you just.
Well, my hope is that when we get done today speaking about this, that you will have an understanding and other members of the committee will have an understanding that when you hear community members say, well, they should be held, they should be doing that, you have an understanding as to what the law is. And I would say that we, by upholding the due administration of justice, whether it's someone who is coming back before us repeatedly, we might not like the behavior, we still have an obligation to make sure we follow the law. And sometimes, exactly, and the constitutional protections, and we'll talk about that. Sometimes as individual citizens don't understand, that's what the law is. And when we get to a few minutes to talk about bail, that's, I think, is one area that people have an opinion of that is oftentimes not informed by what the real true law is and constitutional protections that were actually, a few years ago, I'll tell you, the legislature made some changes to adjust.
Connor, and then we'll continue with the judge.
Judge, who can currently petition for an ERPO? Like, I know the legislature expanded it to healthcare workers.
State's attorney or attorney general.
Okay.
It's not, we don't have a state where it can be expanded. That my recollection was one of the reasons when they look at the due process protections that are put into that type of situation, it provided that as, if you will, the filter.
Great, thanks.
So after someone gets arrested, whether they are given a citation to come to court or whether they have been held, they come to court for an arraignment. The arraignment is the hearing that you so often see, again, law and order. Your Honor, my client pleads not guilty and the state can't do this. And the state will say in law and order, we are asking for remand or we're asking for something. Well, Vermont, we have some different terms. We have ROR. That would be an individual who comes before the court can be released on their own recognizance. And that is where you just say, show up for your hearings. There are cases where even if someone's given a citation, they would come before the court and you're still going to impose conditions. You may not have done it in the middle of the night or over a weekend, but you're still imposing conditions at that time. There are times when the individuals come into court who may have been held without bail, and you will continue that as a hold without bail. Or there may be times where an individual had bail imposed at night, in the middle of the night, shows up for court at the arraignment, and then is released on conditions the next day that don't include bail. And there are times where that person may have bail continued. And so it varies on the case. And again, we'll talk about the conditions of pretrial release and what we have to look at. After the person is released, well, that's where the judicial system process moves forward. Many of you have heard the term backlog. That's basically right now where the backlog is happening between that initial arraignment and the plea or the trial. We have discovery, which is where the parties exchange information in accordance with the rules. They can do depositions and there can be motions filed. And then when there's a plea or trial, if someone's found not guilty, or the charges are dismissed, any conditions of release, any hold without bail, any bail, ends and away they go. If they're found guilty or they plead guilty or they plead no contest, which means that they're admitting that you can make the guilty adjudication, but they're not saying they did it, but it has the same effect. If that happens, then you move on to sentencing. And at sentencing, you have options as a judge. It can be fine or community service. And again, this is one of those slides that's general. There's some other nuances here, but this is really the essence. You can have probation. What probation is a status that you are the judge will impose a jail sentence. You are sentenced to 1 to 3 months in jail, all suspended. When all suspended is mentioned, what that means is you're not going to jail and you're placed on probation. And then you're given probation conditions and a term of probation. If you successfully complete probation, if you don't get violated, if you do what you're supposed to do, at the end of the term of probation, your probation term ends and you have your conviction, life goes on. If you violate and the court finds a violation, and we'll talk about that in a bit, what then happens is the judge has options and can sentence you to the underlying sentence or some other options. But if you do probation the way everyone hopes when it's imposed, you will not serve the sentence. You can be placed on probation and have a part of the sentence to serve. In other words, you can have a jail sentence of, we're going to impose a sentence of 3 to 10 years, all suspended except 1 year to serve and probation, which means you go to jail for a year, and when you get out of jail, you're in the probationary status. So when we talk about, Representative Marcy, you talk about release and that common view that, well, people are coming in and out of jail, we're light on them, I guess, is how people think. Pre-trial release is guided by a statute. And it says that any person charged with an offense other than a person held without bail under section 7553 or 7553A of this title shall, at his or her appearance before a judicial officer, be ordered released pending trial in accordance with this section. What that means is you have to be released. You can't hold somebody in jail unless certain things happen, certain criteria.
So I think we have a question, Judge. John?
At what point in this process, you mentioned backlog, and the state's attorney gets a case, and he has, possibly because of his backlog, he has to triage his cases. He says bad police work, lack of evidence, and he decides not to prosecute. And I think that's what we hear more complaints from constituents in that circumstance. And I don't think the people with citizens watch don't understand the reasons the state's attorneys are triaging cases.
Well, they would do that generally also because they have an obligation to seek justice, not just conviction. So the state's attorney believes that they can't prove a case, then he will dismiss the case as opposed to taking the resources when they could put it towards another case. Those are decisions for the executive branch and the state's attorney. The court doesn't tell them, well, you don't have a great case right now. There are motions that could be filed, but it's up to them as to whether or not they wish to pursue the charges.
Michelle?
Sorry, mine actually goes back to your slide right before this. So I have a question about, in terms of the way this is worded, it sounds like unless you're held without bail, after your charge, you should leave. But what if you have bail given to you, but you can't pay your bail? So like I have a constituent who's been in prison for 1.5 years waiting for his trial. And it sounds like this, like his rights would be violated, right?
Well, this is in accordance with this section.
Okay.
Hold that thought.
Okay.
Because in a few minutes, I will hopefully have explained how we get to that issue.
Okay.
The hold without bail, for instance, this is constitutionally protected. There are 2 ways that you can be held without bail in the state of Vermont. One is a case that involves, as a maximum punishment, life imprisonment. And the case law says when that happens, there is a presumption that you are going to be detained. However, the court still maintains discretion as to whether to release you under what we call the 7554 factors, and we'll talk about those. The other way to be held without bail is a violent felony case. This was actually a constitutional amendment a number of years ago. It started here in the legislature with the enactment, and we went, the state went through a constitutional amendment because this was to hold violent people. And it would be a felony charge, which includes as an element an act of violence. The evidence of guilt is great. The court finds by clear and convincing evidence that the person's release poses a substantial threat of physical violence to any person, and that no condition or combination of conditions will prevent that violence. That's a high threshold. The court has to make that finding. When we have one of those cases, you have to go to trial within 60 days under the law. If the case does not go to trial within 60 days, the statute says the person shall be released on bail. The issue of bail, though, does not mean in that circumstance that the court, we'll talk about this for the factors for bail, does not mean the court has to impose a monetary number above zero. In other words, if the court says there's no risk of flight from prosecution, it can't impose bail, because the reason you impose bail is for risk of flight from prosecution, not to imprison someone or punish them. Under our statutory framework, persons are deemed to be released on their own personal recognizance. That means, again, show up for court. We have your address, we have your phone number, you have to be here. But if the judge says that that's not reasonably going to assure them showing up for court, the judge has the authority to impose conditions. So let's talk about bail. If I ask right now among a group of people, and even this group, what's the reason bail is imposed?
To secure somebody's appearance.
Risk of flight.
Risk of flight.
Risk of flight. How many, if you went out into the community and say, why do judges impose bail? Do you think we might get some different answers?
Mm-hmm.
Oh, yes.
Exactly. And then the question is, well, the judge only imposed this amount of bail. So are there limits to what judges can impose for bail? How many times can a judge impose $1 million bail? Possibly. The sole constitutionally legitimate purpose of monetary conditions of release, i.e. bail, is to provide additional assurance of the presence of an accused. Bail may only to assure the defendant's appearance and cannot be used as a means of punishing the defendant nor of protecting the public. And I highlight that because I suspect many of you would agree with me. This is perhaps the most misunderstood component of the bail system. We hear it, we see it, we read it. They released them on bail, or they released them without bail. Well, if there's no risk of flight from prosecution, and it's not a hold without bail situation, what that tells me is the judge did his or her job, because the judge is not permitted to do that. But what about the amount? Maybe a judge could really put a high amount on it. Well, the Supreme Court has said that while a court need not make a finding as to ability to pay the amount, in other words, the judge doesn't have to say, oh, Mr. Smith, you can definitely pay $1,000, so I'm putting that in. What the court did say is that essentially bail requirements at a level the defendant cannot afford should be rare. We shouldn't have that happen much, according to what the Supreme Court has said.
So can I ask another question?
Of course you can.
So if you have a $50,000 bail, most people don't have $50,000, but you pay, like, can you just describe how does it work, like the bail bondsman? How much does somebody actually have to pay in order to reach that level, in order to be released on that level of a charge?
$50,000 by cash. You have to either put $50,000 up, or there can be bail provisions that say cash or surety, which our law says that you can't just say cash. An appropriate surety, for instance, bail bondsman, that works.
And then how much would the individual need to pay that person?
Generally, my understanding is bail bondsman would charge 10%. We also have under law the ability to impose $50,000 and say that the defendant puts up 10%, with a 10% deposit, if you will. And if you think of it this way, if you give the $5,000 to the bail bondsman, you're not getting that money back. If you give it to the court as 10% down and you show up,
Get it back.
you're getting your money back. So there is a school of thought that makes sense that, you know, if somebody puts down the 10% as opposed to the whole amount, it actually is more of an incentive for them to show up. Because who pays the $50,000 to the court if they don't show up and there's a bail bondsman? The bail bondsman. He or she will chase whoever get the money, like, whether they get it or not. So there are opportunities for different structures.
So the court can also impose an unsecured $50,000 bond, which doesn't require any cash up front, but the defendant would owe $50,000 if they didn't show up. Is that correct?
Yes.
Okay.
And generally what a judge would look at is there is at least one case where the Supreme Court has said that you take it in order. Will an unsecured appearance bond be sufficient? Would a percentage down be sufficient? Or is it necessary for the full amount? And so judges have to consider that as they look at amounts of bail. The legislature actually enacted some limits on bail. And that is at the initial appearance of a person charged with a misdemeanor. If they were cited for the offense, the court cannot impose bail. If they walk in the door on their own and have been cited, they cannot, and were not taken into a custodial arrest, the judge can't impose bail for that misdemeanor charge.
Is that true just for misdemeanors?
Yes, absolutely. And then at the initial appearance of a person charged with a misdemeanor that's eligible for expungement, even if they came in through, we'll say, door number 2 with the sheriff's after being lodged in the correctional facility, the judge even then can't impose bail unless the judge finds that imposing bail is necessary to mitigate the risk of flight. And in that circumstance, if the judge thinks that, yes, I need to impose bail, the limit is $200 on those misdemeanors. So if it's a misdemeanor that's eligible for expungement, the judge can only impose bail in the amount of $200. So if you have an individual in your county, for instance, who keeps coming in, and the judge is only imposing $200, well, that's why, if the judge imposes that amount. And what it also talks about in the law is that judges still have the ability to add other conditions of release. The fact that it's $200 doesn't mean we can't use other tools in our toolbox to make sure that the risk of flight is mitigated and to make sure that someone shows up for court under that, as well as to protect the public safety. When a judge is asked to consider the conditions of release and bail, the factors the judge looks at: seriousness and the number of offenses. What's the nature and circumstances of the offense? What's the weight of the evidence? Is it secondhand hearsay? Do we have good evidence? What's the standard? How much evidence are we getting? Does the individual have a job? What are their financial resources, including their ability to pay? Do they have a past record? What's their record of convictions? Character and mental condition. And on this one, you can look at recent history of actual violence or threats of violence may be considered. If someone is in a situation where they commit a crime and they're screaming, "I'm going to kill you when I get out of jail," or they're saying, "I'm never coming back." I had a case many years ago where the defendant apparently was in the sheriff's car as they were being driven to a medical appointment for something. They came out and said, "Well, yeah, I'll tell you, if I get out, I'm not coming back." That impacts bail. So that information made its way to me. The length of residence in the community. This is a factor courts look at. Record of appearance at court proceedings. Has this person always appeared? There are some people who have a long history of interaction with the criminal justice system, but you know what they do? They show up. They might commit commit crimes that they plead guilty to time and time again. They're showing up. That's what the purpose of bail is. Do you have to impose bail on somebody just because they have a record? If they're showing up, that's a factor. And if after considering all of these factors, the judge finds that there's a risk of flight from prosecution or that the conditions will not reasonably protect the public, the judge gets to impose conditions that will effectuate that, but has to choose from the least restrictive of the following. And those types of conditions are, you can put the defendant in the custody of someone with certain offenses. And in doing that, what issue do you come up with? Who wants to be the custodian? Do they have a custodian? We're here at an arraignment and there's no one who's willing to do that. So it's difficult for judges, I think, to say, well, we're going to place this person in somebody's custody, because if you don't have somebody to place them in, this condition is not something that you can utilize that. You also have, I'm sorry, yeah?
Just going to ask, so if somebody takes somebody into so say they're going to do that, but they don't, is there any fallback on the person that doesn't meet that obligation?
When we have that condition, what I would do is have special language put in. I believe a number of judges put the language in the conditions of release that says, I, the undersigned name, have read, reviewed, and understand these conditions of release. I understand that if I am aware of a violation of any of these conditions, I shall immediately contact Rutland City Police at this phone number. I understand that if I do not abide by these conditions, I may be prosecuted for a contempt of court. So we do put things like that in. But oftentimes, obviously a person who's in custody, what does it mean? Basically, it's keep an eye on them and let us know if something goes wrong. And hopefully by having the eye on supervision, you're not going to have an issue. But you also have to recognize when you're imposing these conditions that it's difficult sometimes to find someone there. And so that's a condition that is not used all the time, but it's something in the toolbox. Place restrictions on travel. If people say, well, I'm going to leave the state and never come back, you put a condition on to say don't leave the state. Whether they follow that might be another question, but you put that condition in. Association, place of abode. You can't live in that house where you just beat up your brother. You have to stay away from that. Or we're going to release you, but if you have to live in this, you can't even. I've had conditions where I've said you can't even go back to this town because of certain conditions. And oftentimes, defense counsel and defendant will agree to those conditions. They want to get away too from the circumstance. You can require someone to participate in drug or alcohol screening to determine whether or not there's conditions that is necessary to impose. You can put no alcohol conditions. You can put conditions in that will say you have to take your medications as directed. Now, obviously, enforcement of those types of conditions is not that, I would say, firm. Take your medications as directed. We're not doing blood tests. So the enforcement of that is something that we're really hoping people will follow those conditions. Yes.
So how does that work if someone realizes that they've got a substance use issue and they agree to go into treatment, and then there isn't a bed available for 3 or 4 weeks? Are they detained until that bed is open, or they can stay in the community until the bed is open?
Stay in the community because they can't.
Without treatment, though?
They can't comply. It's not their decision to not comply. They're not able to.
Yeah.
And remember, we can only hold people without bail under 2 circumstances: life imprisonment or the violent felony. So their inability to get a bed, I can't say, oh, you're now going to go to jail instead of a bed. If a judge believes that their issue with substances at that moment and the inability to go to a bed at that moment is such that there is an instability giving rise to a risk to flee from prosecution, a judge could possibly impose a condition of some bail, which would detain them. But then if they paid the $1,000, then they're out anyway.
So with this second bullet point, how often does that actually work out, that you're able to sentence someone to treatment and they're able to go in?
My understanding recently, for instance, Washington County, I'll use that as an example.
Yeah.
If we order that, I'm told that Washington Mental Health is able to get that. In Rutland, if it's ordered, my understanding is they are able to get in for assessments.
Wow.
There are difficulties with getting treatment, though.
Right.
They can get the assessments, but the follow-up treatment after that is where we, as a state right now, are having difficulty delivering, whether it's mental health or substance.
And would we send somebody out of state for treatment, or it has to be within Vermont?
I am not, when a judge enters this order, the judge is not sending them to a specific location necessarily. The judge is saying, you need to go and do this. So if they want to go out of state and there's no condition prohibiting it, that's fine.
We have another question, Tristan?
Judge, I'm curious if you might look at something, the wellness of the individual, look at mental health. It's a conditional release order, grief counseling, for example. I can think of an individual that committed a crime, I think in a period of crisis due to loss around an opiate use victim.
I would not order that type of counseling. And the reason I would not is I would order them to see a mental health professional and follow those recommendations.
Was that, okay.
I would not get as specific to tell them what kind. For instance, in domestic assault, I may think that someone needs batterer's intervention or think that that might be something good. But if you put someone with a need into the wrong program, you actually can do harm. And so I leave the specifics, as you said, grief counseling.
Okay, so backing out of that, you would order mental health services.
I order mental health screening and follow-up treatment recommendations. Absolutely.
Thank you.
I just don't jump that next level and say, here's what it is. Even though perhaps we're all sitting in the courtroom and think that's where it is, that's above my pay grade as far as expertise.
No, you answered my question. I just drilled down too deep. Thank you.
We can order, as Representative Trena mentioned, we can do secured appearance bonds, we can do unsecured appearance bonds, we can require sureties, which is bail. Sometimes people will bring houses. They'll pledge real estate to secure release. We can also impose any other condition necessary to mitigate the risk of flight, including returning to custody for specific hours. This one is from the legislature. I would note that even though, I don't mean to push back on you, even though it says any other condition, we still have to make sure they're constitutional. And so any other condition could be, well, I'm going to put you in, you're going to have to go to this house and go to jail. No, we can't do that. It has to be a constitutionally permissible type of condition. And then we can also impose, by a similar nature, any other condition found reasonably necessary to protect the public, except physically restrictive conditions can only be employed in extraordinary circumstances. Physically restrictive, curfews, things like that. People think, oh, you need to impose a curfew right away. That has to be done in extraordinary circumstances when you're affecting someone's physical restrictions of where they're going to be able to go freely in our society. One other condition that courts can order, outside of that, the legislature you have enacted another statute, section that specifically says you can order conditions that say not contact and not harass certain people. This section is not, remember a few moments ago where I said you have to impose the least restrictive conditions? This is a different section. This is not in the same subsection as least restrictive. In other words, this does not have to be the least restrictive condition. The judge can say, I'm ordering this, even though maybe there's something less restrictive. For instance, you might have the ability, when someone comes in and you have the two parties that had a domestic dispute, and they say, well, the man is accused of assaulting the woman in front of their child. And they come into court and they both say, we want contact. We want it. And the victim, the putative victim says, it won't happen again. I would like to have contact. And maybe the judge could say, well, the issue is the harm will come from physical contact, right? So maybe I won't have them. The least restrictive might be just don't get together in the same room. And maybe they can have telephonic contact or email or FaceTime. That could be least restrictive. But a judge might conclude, wait a minute, this just happened. And I've got real concerns reading the affidavit about abuse and control issues. I've got concerns that if he's going to be talking or they're going to be talking, it might have an impact on someone's mental health, or it might influence how they're going to go forward here. And so initially you might say, I recognize that I could have less contact, but we're not going to do that. No contact means no contact. If you want to come back in the future, you have the opportunity to review conditions of release. The parties can come back. And I will share that I was a judge who believed, if you will, one step at a time. That I do not want to see families torn apart. I want to see families built. But like anything we want to see built, we want to see a firm foundation that's going to withstand what weather throws at it or what light throws at it. And so I would say you can have email contact and FaceTime, for instance. And then if that goes well and there's no violations for a while, then you say contact in a public location in the presence of a third party. You can go to there. And then you can go back to, at some point, if the case is not resolved, you're faced with circumstances where some people may have been apart. You're now having contact in a public place or even in locations with third parties present. If the case is now 2 years old and they want to get back together, what do you do? And so judges have to decide those cases. But this condition is one that is used for good reason. There's also...
We have a question. So this is all at arraignment, that this is all happening?
Yeah.
Correct.
Okay, just to be clear. So Chip, you had a question?
So I just wanted to bring up the possibilities of family or no order, no contact order, whereas the one party is the earner in the family, and it leaves the second party as without funds, ability to pay rent and function in their family. So that's a consideration sometimes the judge will need to face as well, I think. And so that's, as you say, a good foundation is it's the basis of a good family. So we've run into those occasions in the past.
Just wanted to open up, I had, every now and then when I see something, I had a clue and it didn't give me the next line, I'm going, okay, there's a glitch, so I'm gonna reopen it to make sure it goes. Technology is a wonderful thing when it works.
When it works.
Right.
When it works. Let's hope it works. So one thing that we did while the judge is figuring this out, one thing that we did a number of years ago, 8 years ago maybe, pretrial services. Were you in the committee, Mary, for that? This was at the point that we really were looking to have an intersect in terms of, here's the arraignment, and before it goes to trial, it goes to court again, let's have an intervention here. So if it's really obvious the person's got some mental health issues, or it's really obvious a substance use disorder, let's see if we can get this person into at least an assessment situation for that. And that's why sometimes there is that availability in our DAs or a substance use disorder program to at least assess the person. And the goal of that is to get the person connected immediately. As soon as they leave the arraignment, to at least have them get a connection with a provider and do an assessment and then set up a time to follow up. And that was part of our pre-trial legislation in terms of helping someone get connected immediately, not have to wait 2 months to make a connection, because then you've really decreased the effectiveness of that. And then hopefully the person will then get connected and be able to become engaged in some therapeutic programming that then helps them when it comes up to the point of actually going to court. So that is what a pretrial services was all about. And it did at first become housed in Department of Corrections. And that did get moved to the Attorney General's office about 4 years ago, I think it was.
That's what Annie started doing, who was here yesterday
Right.
speaking to us.
Right,
was
but
her
that
first job.
legislation came out of this committee.
And when you look at the conditions that we were just talking about, I think in practice, what is going on is what Chair Emmons says, and that is there is a recognition by the judges that the sooner we get someone treatment, the better they will be.
Yeah.
It helps them, it helps society, it's a win-win. And that's why oftentimes it's frustrating when mental health, for instance, we know that there's a lack of beds. And that creates issues for us as far as getting someone who might have a significant mental health issue that's just not being addressed. And so we want to get people treatment as soon as we can. One of the other things that another tool in the toolbox is the legislature adopted home detention. And I will say that as I was putting this presentation together, I went, put it in, don't put it in, put it in, don't put it in. And Chair Evans was smiling, but she knew it hasn't quite been worked apparently the way everyone thought it would when it was adopted. And so home detention is this. A defendant is placed on bail. The court imposes bail. They can't make bail for at least 7 days. They can ask the judge, or DOC can ask the judge to say, we want to do a review and consider home detention, electronic monitoring. You're released, you sign a contract, and when the judge is deciding this, the judge has to look at the nature of the offense with which the defendant's charged. You look at all the same types of factors that we looked at for release. You look at the risk to people who are going to be in the residence and other areas. And if the judge agrees, then they're released. The bail is still, if you will, in place. $25,000, let's say, that bail is still there. But if they're on home detention, As long as they do what they're supposed to do, they're out of jail. They're in their residence of detention. But if they don't do what they're supposed to do, DOC, the Department of Corrections, arrests them and takes them back to the facility. And at that point, they're held on whatever those conditions were with bail. So theoretically, if someone's on home detention and they violate, they go back to jail, if they post bail the next day, they're walking out. No home detention and no bail. They're following the other conditions that have been imposed. As of today, I believe the number is, actually, as of yesterday afternoon, I was told by DOC the number is, oh, you're so close, it's 10.
10, I almost did 10, but I didn't quite do it.
It was 10, and I have to acknowledge, I was surprised it was that high. If you would have asked me, I would have said 5 or 6.
Yeah.
And I reached out to a couple of judges and said, why? And they said, people just aren't asking for it. It's just not being requested.
That's right.
And what also happened a few years ago, when the statute was originally passed, it had, I'll say, an ambiguity, if you will, such that there was a view that it applied for people who were being held without bail. So every time someone was held without bail, it was a violent crime or a life imprisonment, there was a determination by the court that, well, they can get home detention. My understanding is the legislature heard that was happening and said, well, that's not what we intended. And so the statute got changed. So if you have someone who's being held without bail, they are not eligible for this home detention. And that's one of the reasons why the numbers went down also. Yes.
So if you have home detention, do you have to have electronic monitoring with that?
Yes.
And there's a charge associated with that?
I don't know about the charge part in terms of pretrial detention.
For pretrial, there isn't a charge? Because I know people that go out after that it's expensive to have an ankle monitor.
There may be, I don't know, I wish Isaac was still here, I'd ask him.
Okay.
Because I don't know.
Because my understanding is having an ankle monitor is very expensive, but I didn't know if they provided it free of charge, that would be different.
I have not been made aware that defendants pre-trial have had to pay that charge. That doesn't mean they don't, but I'm not aware that that was a consideration. I don't think they do.
Felony would smash it.
So we have another question, Gina, and then Tristan.
The number 10 that you mentioned earlier, that's not including the electronic monitoring that's done for people that are on probation.
It is
correct?
not.
Yeah.
Detainees are different.
Pre-trial.
Just, yeah.
Detainees who have not been convicted. They've only been charged and arraigned. So, and home detention came out of this committee. And I remember Mary interrogating me on the floor. That was part of reporting the bill. No, and you weren't in the committee. But it was a tool that we wanted to put in place as a pressure valve, release valve to our detainee population, because we just don't have the beds. So we put in that initiative to do it. We're hoping it was going to be successful, and it never seemed to take off. We even had a pilot project with the sheriff down in Windham County. That may be where the fee comes from, because it could have been from the sheriff's office to pay for it.
That was under section 7554D, or that was under one of the 7554D, I think, but it's that even sunset. Different Sheriff Clark's gone, and that sunset in 2018.
Yeah, because there were some real complications on that one. It wasn't playing out as we had hoped.
Yes, you should have listened to me.
I did. I'm glad we got you in the committee. Kristen.
Thank you. I think I'm just trying to understand a little bit better why it's not being used. And you said they're not asking for it. The police officer, the attorney, the judge, they're not seeing it's a fit.
The defendant or the Department of Corrections could ask for it, and they just haven't been asking for it.
So the defendant isn't saying, they're not finding something attractive in that versus the alternatives.
Some defendants just don't believe it's something they want to do, as opposed to just staying with the original conditions, and they'll go and post bail as opposed to doing home detention.
And why, we don't know. I mean, it's counterintuitive.
Are they staying incarcerated? They're not. It's not.
If they post bail, they would not be incarcerated, and some have just chosen that they don't want to go through it. Some have no stable, reliable place to live, and that's a criteria for it. That's an issue that we're facing.
Yeah.
So I just want to put a little piece out, and I think it would also, I think home detention also qualifies for this, I think, but I'm not sure. For a detainee, for every day that they serve as a detainee, and I think if any day they serve in home detention as well, would be credited towards their underlying sentence.
Correct.
So if they're serving, if they're a detainee, and they're incarcerated for 2 years before they go to trial, and their sentence is 10 years to 20 years, you've got 2 years already off the minimum that they get credit for. That may be the incentive for some folks to stay incarcerated.
Yes,
So we have roughly 499 detainees right now.
today 420.
Oh, good, it went down.
State detainees,
the state.
you're including federal.
Oh,
State
okay.
is 420, I believe. this
Okay,
morning.
so there's 10 home detention that are in that.
I didn't do it.
They're not listed as detained, they're out. If they're not detained, they're out.
Shut up.
I was interrogated.
Via cell phone, right?
I want to touch on, since you're the Corrections Committee, Department of Corrections supervises people on probation. So remember back in sentencing, if someone's put on probation, if they don't perform the way they're supposed to when they're walking around the street and living their lives, well, the probation officer can file a VOP, a violation of probation complaint with the court. And the probation officer can sometimes give the person a citation or arrest them. Well, probation officer decides they're going to arrest them for the violation. The law provides that when they arrest them, they will lodge them. And they are held without bail, or sometimes the probation officer will seek a warrant from the judge and bail could be imposed. But they go to jail. If they're arrested after hours on a VOP, unless the probation officer decides that he or she wants to cut them loose, they're held until they come in. If they're arrested without a warrant, if they're arrested with a warrant, the emergency arrest is filed, they go to jail, and then they come to their arraignment. And so the probation officer decides on how that's going to go, like the police officer decides. If the probation officer, that's why our numbers, if you will, today it's 420 for state detainees. If 50 people were arrested today for violation of probation, tonight, they'd all go to jail if the probation officers do that. And then tomorrow, the number would spike in the morning. And then if they're all released later on conditions, the number will go back down. And so that's up to probation. And when they come to court for the arraignment, it's up to the judge. But we are guided, of course, by the statutes. And the statute says that pending arraignment, they're held. However, after the arraignment, the court can release them on conditions. Remember those factors I mentioned before that we have to look at? That's 7554, so we have to look at those. There is no right to being released when you're on probation except for a nonviolent misdemeanor or a nonviolent felony. If you're on probation for a domestic assault and you get arrested and come before the judge, he or she can hold you. They do not have to release you. There's not a presumption. When you're a pretrial, that early section, when you're charged with a crime before a conviction, you have the presumption of innocence. And the law is designed to uphold your constitutional rights under that. Here, you've been found guilty. You're in a status of being under the Department of Corrections supervision. It's a conditional status because it's conditioned upon, if you will, good behavior. And so you can be held if it's not, unless it's a nonviolent misdemeanor or nonviolent felony. If the court finds that conditions of release are going to work, they have to release you. It's required. A nonviolent felony is a felony offense that is not a listed crime under Title 13, Section 5301, or crimes involving sexual exploitation of children. A nonviolent misdemeanor is a misdemeanor that's not a listed crime, or one involving sexual exploitation of children.
So we have some questions here. So Tristan and then Michelle.
Thank you, Judge. This is so helpful. Basic question I had was at the federal level, the probation is under the judiciary, if I'm not mistaken. And can you just explain how that's different in Vermont?
In the federal courts and in some states, the probation officers work for the courts. So what will happen is, for instance, if you're going to be involved in you have a probation officer in the federal system, there's a violation, they'll go meet with the judge to get the paperwork signed, and before sentencing, they will meet privately with the judge and talk about the case. They work for the judge. It's not, if you will, ex parte, which means outside the presence of the parties, because they're the same party. In our state, Department of Corrections is a party, if you will. They don't work for us. We may order them to do pre-sentence investigations and other things, but that's because the statutes provide us that authority to order certain requirements. But we don't tell them what to do and how to do it unless the statute lets us do that.
Michelle?
Yeah, so my question relates to where you were talking about if somebody is on probation and they have a violation, and then you have what a nonviolent misdemeanor is. So is that referring to the violation?
No.
Or the original charge?
The original charge.
Okay.
They're on probation for a nonviolent felony or nonviolent misdemeanor.
Yeah.
The nature of the violation, if the violation is you're not allowed to drink alcohol, and the probation officer shows up and you're drinking a Budweiser, and you go, yep, I just drank a Budweiser. That's a violation of probation.
Right.
That's not a crime.
Right.
But it's a status offense. If the probation officer shows up and you're a felon and you've got a handgun sitting on your lap, that's another crime.
Okay, all right.
But that does not define the initial part. So if it's the latter, let's say it's a person with the handgun in their lap, and it's a nonviolent misdemeanor that they're convicted of, they're convicted of disorderly conduct. Well, that's what we have to apply to sort from that original charge.
Okay.
And,
But the housing that they're released to for their probationary sentence also has to agree to certain conditions as well, if I'm not mistaken, right?
When you are having, generally that's for furlough.
Okay.
Furlough, there would generally be a housing review, same as home detention. They review the house, there's requirements there, because furlough is really an extension of the jail. The house is part of the jail because they're still under the custody of the Commissioner of Corrections. In probation, it's not quite the same. Yes, DOC would go out if someone's living somewhere to make sure that they can live there. But the restrictions that we can impose as far as residential restrictions are not as broad as those that can be imposed under furlough when someone is actually in jail and getting out because of that.
Wayne?
Yes.
To skip back to your home detention, not many people are using it, but are the defense counselors aware of that? Or,
Absolutely.
So it's not.
This is not a
communication problem.
Correct. This is not an issue of letting people know that it is out there for opportunity. It's just something that's not being utilized. And I don't know if maybe we'll see more of it utilized now that we're coming out of the pandemic. But if someone is, let's say you come before the court for the violation of probation, what do we do? Well, you can revoke probation. You haven't done what you're supposed to do, and there's some criteria the judge has to apply. You revoke probation, and you're serving a 1 to 3 year sentence. The judge can also decide, well, I'm not going to revoke probation. The judge can continue the probation on the existing sentence. Don't do that again, and everybody decides you're going to stay on the exact same sentence. The judge can say, we're going to extend your period of probation a little bit because you've shown an instability here that we want to make sure. You're within 3 months of ending it, and you're not giving us the level of performance that we want, so we're going to extend it for a year because we want to make sure that you get the help you need for rehabilitation and society is protected. You can conduct a formal or informal conference in order to re-emphasize to him or her the necessity of compliance with the conditions of probation. That would generally be done on the record, and you look at someone and you have that, we'll call it, come to
Jesus.
You realize that you are facing 1 to 3 years. You have a family. You've got a great job. Do you understand that if you keep doing this, it's going to lead you to jail? What is that beer? And I've said to people, you keep drinking. I want you, when you look at that bottle of beer, to imagine your daughter's face on it, because you say she's the most important thing. And is it worth drinking that beer to be away from her for 1 to 3 years? And if the answer is no, and I know that's what you think, it's no because you love your daughter and want to do best, you gotta get the help, not showing up at treatment. So we can have that type of interaction with people to hopefully try to adjust their behavior. And oftentimes, if you have someone come before you and you're just telling them how much of a failure they are, you say, oh, you keep screwing up, you're terrible, you've been like this your whole life. Well, don't we recognize often that that person probably had someone wagging their finger at them and chastising them for most of their life?
Yes.
And if we're just going to keep kicking them down, we're probably going to get the same result. And so it's incumbent upon us as judges, and I know probation officers try to work with people to help them, but it's incumbent upon us to try to help people get the help they need. And there are those times where we say, you know what, we're at the end of the situation and I'm comfortable, it's got to be an incarcerated sentence, so we have to do something different. And so we can impose that. We can give warnings, and then again, we can also give a sentence where they have to serve a part of the sentence. In other words, we can say, you've got a 1 to 3 year sentence. You're now going to jail we're going to impose the same sentence, all suspended except 30 days. You're going to go to jail for 30 days. And when you get out, hopefully you don't do X, Y, or Z and life is good. One of the things that people talk about with jail too, when you put somebody in jail, you are taking them away right now, at least, from the opportunity for that immediate treatment, that immediate substance abuse or mental health treatment. I know that DOC has beds and specialized units, but it's not giving them mental health treatment at a level that I think everyone would agree we need to give people to help them immediately. We also bring in employment instability. If you have somebody who is screwing up, but they have a job, and they're showing up at their job, and they're earning a living, they're supporting their family, they're paying their rent, they're doing everything, but they just can't stop drinking. They're not driving, they're not out committing new crimes, they're just an alcoholic, and they're not getting the help they need. Is putting them in jail for 30 days something that's going to change their behavior? Those are the types of questions that judges need to wrestle with. In contrast, you have someone that's no substance abuse, no alcohol, they just keep doing things that they know they shouldn't be doing. Maybe putting them in jail for a few days will have them understand the benefits of good behavior. I will share with you years ago, I'll not give you his name, but there was someone of, I'll say some renown. It was a college athlete in Vermont. He got into a fight. And I actually have his permission to say this. I hope I do, because he told me I could. I hope he remembers, it was a long time ago. But he got into a fight, and he beat someone up, and he went to court, he was charged, and when he was sentenced, he was given a probated sentence, but he was given 30 days to serve. And there was a lot of, you could read about it, people were saying, why, it doesn't matter, or yes, he should have gotten more. And so when I met him, I was introduced to him as a judge. He was still playing the professional sport that he was playing, and my son happened to work for the team. And my son introduces me and says, yeah, from Vermont, what do you do? And my son said this, he's a judge. And the player said to me, do you know Judge Blank? I said, yep. He goes, tell him thank you. First 30 days, I thought about what got me here. Next 30 days, first 30 days, I think it was, I thought about where I was. Next 30 days, I thought, next 10 days, I thought about, it was 10. Next 10 days, I thought about what got me here. And the next 10 days, I thought about what I was going to do when I got out and never come back.
Mm-hmm.
Success story, no recidivism. Life was good from then on. But that type of decision was not easy on the judge, was certainly not easy on the gentleman. But it was something that as judges, we look at when we're imposing jail sentences. And so I know that there was a question that this group had that said, basically, if we build it, will you fill it? Something like that is often asked. And the short answer is, you can never tell. We don't know what the future holds for individuals to go to jail because we sentence individuals. We address people's lives. Everyone's different. And we don't know if we have a number of crimes and people deserve to go to jail, judges are going to do what's necessary. If you ask me if we build mental health facilities with beds, will you fill it? That one's a yes. So, yes.
Troy?
So I believe that, right? I believe that our intention is to follow these objective checks as we're applying a sentence or determining incarceration. I guess my question, I gotta figure out how I want to ask this. My question is this: so when we look at the numbers of currently detained people in Vermont, and correct me if my numbers are off, but these are based on numbers I heard probably 2 weeks ago now. And the numbers are so different from women detainees as they are for men, right? So 50% of our incarcerated women population are pre-sentencing. And I think it's 30% of the men or something, right? That's a huge red flag for me, right? And if I know that our vacancy, our available beds for women is higher also, I gotta ask, what are the checks and the biases that we have in that process, right? How are you training judges to be as deliberate as they can about checking their biases?
The topic of implicit bias, we'll say, or explicit bias for that matter,
certainly,
is something that is critical for a judge to recognize. There is a Second Circuit Court of Appeals federal judge, Jerome Frank, who said that the wisdom in addressing biases is to recognize that everyone has them.
Yeah.
And that's how you can, if you will, blunt them. In the judiciary, when a new judge is appointed, we do judicial training. Every judge goes to the National Judicial College General Jurisdiction Program. At the National Judicial College, there's a section, a course on neuroscience of decision making that gets right into the implicit bias. But one workshop or one program doesn't solve everything because it's a work in progress for all of us. So what we do is we have Judicial College, our own in Vermont. Since 2019, each year we've had sections on implicit bias. We have a session coming up this June. So we have courses on what's called procedural fairness, which address issues of bias and prejudice. So we take a view in the judiciary that there has to be an awareness of the issue and steps taken through education and self-reflection, which comes from the education that we recognize. I have to look in the mirror and see, who am I and how do I address these things? So we are addressing it through educational endeavors, and we continue to.
Why do you think the women detainee population is so significantly higher than men?
I have not looked close enough at that to be able to give an answer that I think would be informed. Our number today, I believe, was 420. On January 13th, I believe the number was a little higher, 450 possibly, but on that day, there was 230 of the detainees. Well, actually today, it's about 230 detainees, I think, who were held without bail. That's what the number was back then. So more than half of the people who are pre-trial, when I got the information from DOC on the 13th, were being held without bail. And that's something that we have to, when you look at how we get to where we are with numbers and such, that's something we have to consider. And so what we are trying to do in the judiciary is to make sure that those cases are ones that take priority, to address those cases, because we should be able, there shouldn't be 230 people in our state being held without bail for extended periods of time. We need to start getting the backlog addressed and take steps to have the trials. And we're doing that throughout the state. We're making our efforts to do that.
So we have a lot more questions. We have Wayne, Tristan, and Michelle.
So we got the ones held without bail now, 400. So the rest of them, what category are they in? And then I would go back to the question we were talking about the women. How many of the women are actually held without bail as opposed to the other category? And so we're getting to the point of, do we have how does the court backlog fit into it, and how does COVID fit into the current numbers as opposed to a trend?
Well, COVID has you can't blame everything in the world on COVID because we had backlogs before COVID. I would love to sit here and say, we were so great, everything was running smoothly, but then COVID came. No, we had backlogs before we had COVID. And COVID has exacerbated them in a significant manner. And that's a problem. And so we need to take steps to address them. This is the chart that I received from Department of Corrections as of the 13th. As you can see here, on that date, it was 420. That's the number of people. In the middle, HWOB, there was 230 people held without bail. And this gives you the categories under $1,000, and it goes right up through there. This DOC keeps track of this, and so that's where I get this data.
So that one, there were 12 women that were held without bail.
Yes, if you look at Chittenden Region,
Yeah.
12 women were held without bail. That's correct.
You have 2 that were held with less than 1,000, 5 with 1,000, and then 10 with 10,000.
So that, on that day, there were 35 women.
And then there were.
That doesn't include federal.
Right, no, we saw a number, when we saw number 50, we were told within the last 2 weeks, but I think that included about
Federal,
15.
yeah, there are 15 to 17 federal.
I'll go to 35, 230 out of 420. I'm just looking to see if there's a real disparity given categories, right? See, it doesn't look
Well,
like.
that's held without bail, but total detainees.
Total detainees. So one thing we have heard over the years about why sometimes women are taken up in bed, whereas a man may not be, is, and I don't know how true this is or not, I'm just putting this out, that we've heard over the years is that quite often a man has somebody backing him up, where a woman has burned a lot of her bridges. Where for some of the males coming in, there may be a mother, a wife, sister, somebody that, yeah, I can provide housing for this person, they can stay here, there's some support systems. But for a woman, over time, sometimes they show up at court with all sorts of violations, but they have no place to go because there's nobody there to provide any services for them. Now, we've heard that in testimony in this committee over the years. I don't know if that's been true or if it's still true, but that's what we've heard. So I just want to put that out there on the table because we've heard that. So I don't know if it's true or not, but that's what we've heard.
One part of me is saying, don't answer that, don't answer that.
Sorry about that.
That's okay, because it's a great question. And as you're telling me this, I'm actually in my mind, I'm sitting on the bench and I'm looking at some women who have been before me. And what it's kind of running through my mind that while there were some who had very strong support systems, you're describing a number, I can put my finger on a number of cases where you just described a situation. The woman in certain cases just, if you will, burned the bridges, kept stealing from mom, kept for drugs, and just kept burning the bridges. And they come in, there's nowhere for them to go. And the probation officer is saying, we really want to have them go somewhere. I can't say that there's statistically that is valid, but I can say that on more than one case, yes, I have seen that. And that's going to now make me, when I leave here, go look into that more because it's a great question.
It's what we've heard here. So.
I just want to say, I think when you're asking those questions, you have to couch that within the societal fact that women have fewer bridges to burn.
That what?
Women have fewer bridges to burn to begin with.
Yeah, they do.
That's, misogyny, right?
Well, and also males tend to have women that support, that back them up. They have a mother, they have a sister, they have a wife, they have a girlfriend, something where a woman sometimes doesn't have that support network to back her up.
I can assure you, my goal, at least in my position, is our number today at 420 for detainees. I want that number lower because
we all do.
Number one, I want individuals who are involved in the criminal justice system to get the skills they have and get the help they need to not go back to court. We genuinely want to reduce recidivism. So if we're able to do that, the numbers will go down. And yes, we're never going to have a society where it's, oh wow, there's nobody in jail. It's zero. We know that. But we can certainly address a large number of people who, whether it's mental health or substance abuse, especially now coming out of the pandemic, the pressures that people have been under are unprecedented. You take somebody who has mental health issues and we go through the pandemic, that's going to exacerbate it. And we have to recognize that special times are for special circumstances and for special results, special situations that we need to rise to in the judiciary. And that's why when we look at how we're doing things, if you have in your committee any suggestions, any comments, any criticisms, or anything we can do better, let us know. Please, you'll see me around here. Don't hesitate to say, hey, Judge, I got a question for you. And it's like today when we started, Representative Marcy talked about the revolving door. It's my hope that when you talk to people in your communities, if they say, well, why are they revolving? Well, unfortunately, when someone is alleged to have done something wrong, unfortunately, when someone is alleged to have done something wrong, we have to make sure that their rights are vindicated. And unfortunately, sometimes people don't understand what that means in society. And if you're the victim, I understand why victims may not get it or may be frustrated, or society members, the same thing keeps happening. And one of my jobs, I think, is to try to make sure that judges know the law through training, make sure we follow it, and to the best of my ability, let the legislature and let the citizenry know when I can. Here's the way it works. I get letters from people saying, this is ridiculous. How did this happen? I can't get involved in specific cases per se, but I can try to explain, well, that's the law.
And then we get the blame.
And so as you go forward, don't hesitate. Let me know any questions.
So we do have a couple questions here, Tristan and Michelle.
Judge, I wonder if some of what this public misperception about bail might reflect is a sense of powerlessness that I think we've all felt in our communities in situations where it does feel like there are crimes that are happening more often than they were before, that people are in distress in various ways. And so I'm going to take you up on your offer of trying to think of ideas to address this, and I appreciate that. But since you're in the hot seat today, do you have any sort of sense of what's happening in our society right now?
That's, I think, too big of a question for me to be able to say societally. What I can say is we have all been through a pandemic, and the pressures that it has caused financially, emotionally, mental health issues. We are not in Vermont, as great as we did through the pandemic, statistically, immune to the problems that arise from it. You see it in your courts with whether it's financial issues in the eviction cases for housing for people who can't get housing. You see it in the family court, you see it in the juvenile division, and of course you see it in the criminal division. And so I think we have a lot of things coming at us in the criminal justice system, and we just need to take one step at a time and try to find a way to help people and recognize that sometimes when people are coming before us, they're not going to understand what's happening. We have to assist them in doing that. We can't just say, oh, you know what, you're in court, you should know what's going on. And if you don't, because you're going to go to jail. No, we need to help people. And we also need to recognize, and we're talking about this, we have a mental health commission Chief Justice Reiber is working on, and we're going to be doing training with people about how do you recognize mental health issues or substance abuse issues in the different systems, whether it's probation officers, police officers, judges, staff, people in the community. We want people to be able to recognize it, to be able to help people. Have you heard the term sequential intercept model? Where on a line, you try to get people help at different levels. Here's a place we can get them help. And if they get beyond that line, well, there's another off ramp to get help. We're trying to put things in place to help people recognize issues that we can help people get assistance that they need. And so I can't say that there's an easy fix to where we are. What I can say is we're taking it, if you will, one day at a time, but we're planning down the road to make sure that everything we do is going to get us to that goal, and that is a safe Vermont and to do administration of justice for everyone.
Thank you, Your Honor.
So Michelle?
Yes, so this has two parts. So you had mentioned earlier in your slides that the held without bail status is supposed to have a 60-day maximum sentence, like their case is supposed to be resolved. Now, you hinted that we're long behind that, but we're not able to comply with that. So could you, I guess the first question is, how far beyond, how much beyond 60 days are people being held without bail? Like those 230 people, how long have they been there?
The hold without bail 60-day is only if you are being held under the subsection 7553A for a crime of violence under that specific section. If you are held under the life imprisonment case, there is no 60-day requirement.
Okay.
So I don't, DOC I did not ask to try to get that differentiation. And I don't believe our Odyssey system captures that data point.
Yeah.
So I don't know how many are 7553. I know it doesn't capture that data point.
Yeah.
I don't know how many are 7553A as opposed to 7553. But what I will say is that the 7553A, whatever number there are, it should be less after 60 days. In other words, not 60 days because you have the trial. And then if there's a conviction, you would still be reflected as a detainee until sentencing.
Mm-hmm.
But that number we should continue to do trials to address that.
Yeah. Well, then the other thing sort of related to that, you had said, this should be a priority. We want to move those people through so we know what's going to happen with them. So I guess my question would be, what about people who have a bail, but they can't make their bail? So they're awaiting.
Same.
And so they wouldn't be in that prioritized category necessarily.
We are prioritizing individuals who are detained. So the 60 days cases, because of the statutory requirement, they are the top of the line, if you will.
Yeah.
They have a statutory requirement. They have to go within 60 days. The 7553 cases for life imprisonment and cases where someone is held without bail, they don't have that 60-day requirement, but we are prioritizing all of those cases. It's not just the hold without bail. If you've been in jail because you can't post $10,000 and you've been there for a year, your case is prioritized. So when we came back online, if you will, after the pandemic and started doing jury trials, the focus was we want individuals who are detained. Those are the cases we want to be coming into the courts.
So how long do you think it'll be till we actually work our way through that system of people that are still waiting?
It's going to be a while. Unfortunately, if you look at the number of cases we have in the state, we have, I'll say roughly 14,000 criminal cases. Out of those 14,000, we have 420 of people detained. So if you had 420 trials throughout the state, you have to do the jury draw, you have to do the trial, it's years.
That's the days to do.
We have 14 counties, but if all we were doing was trials, it's still going to take a while. If we took 365 days in 1 year, and that's not counting weekends and holidays, it would take over a year if we were trying every case for 1 day.
So does the judiciary ever go back and look at the cases of, I happen to know an individual who was held on a $200 bail and he couldn't pay it. And this was the beginning of the pandemic and he was incarcerated for almost 4 months. And by the time he got to have a trial when the system got set up, they were like, whoa, you've already served way more than you would have been charged with. Time to go. So at this point, there were, I don't know, a dozen or 24 people that would be in the misdemeanor category that have bail, but they're still there. Would the judiciary reconsider, does this make sense to be holding somebody for 2 or 3 months while we're waiting for their trial because they don't have $200?
Individuals who are held for lack of bail have a right to a hearing to have the judge review that. If they file a motion, the judge has 48 hours to.
And how often is that reversed? Is that?
Well, the judge can reconsider it and say, okay, we're going to look at this differently now. Absolutely.
But the better question is, how many times is it asked to look at?
How many times?
How many times is it requested to look at again?
Well, that's the question. When I'm hearing about an individual who's there for 4 months and
I don't think he knew that was possible.
But he was represented by an attorney, correct?
Right.
Sort of.
If he's in jail, he should, unless someone wants to represent themselves, if they're in jail, they would be entitled to a public defender.
There was a public defender that was very hard to reach. Yeah.
So attorneys definitely would have the ability to make filings to bring that to the attention of the court. What we are doing is on a monthly basis, we're providing data to the judges for spreadsheets. And those spreadsheets talk about these cases. So the judges are able to see their older cases and where they are. I've actually, I will acknowledge that list that I showed you from DOC and that below 1,000, I wondered what those cases look like. So I'm putting together a spreadsheet. I'm actually taking the time to look into those cases to see who are these individuals for less than $1,000? How long have they been held? And what's the status? Again, I don't intervene in cases, but if I get that information, I'll be able to address it better as we go forward.
So we have a couple more questions and then we got to wrap it up because we're going to shift for another topic with our legal counsel. So Chip and then Wayne, and then we'll have to wrap it up.
To speak to the situation we were just speaking about, in Newport, Attorney Slay had filed a motion for a speedy trial, which is the remedy for being held for over the certain period of time for a misdemeanor. And the judge actually did dismiss charges against, I think, 4 defendants who were held on relatively minor misdemeanors. Probably shouldn't have been held to start with, but dismissed those charges for lack of speedy trial. So that is a remedy. It has to be filed to a judge in order to get that before a judge to do that. So,
Wayne?
So mine is probably a good wrap up. In terms of capacity of the court system, in terms of personnel as well as buildings, that sort of thing. What are your thoughts given the trajectory of backlog and everything else? Are there deficiencies that need to be addressed in the future? And do you have any thoughts on that?
When you say deficiencies, I'll say we need more staff. Whether we call that a deficiency or just an unfortunate byproduct of where we are. Department of Corrections, I know, needs more staff too. Part of our budget this year, Terry Corsones in Advancing talks about additional staffing resources. It's critical. We have, whether it's the expungements or the cases we're dealing with, we need more staff. We've also put in for another judge to be appointed as well as a law clerk. And those, if we got all of that, that would help us go forward. Buildings, we're having, like many areas, security is an issue because the sheriffs are having difficulties getting staff. And so we're working on that. But I would say staffing is something that's very important to us.
Do those expungements ever result in someone going back to court to try to get their sentences changed?
I'm unaware of that. I can't say that I'm personally aware of that. That's not to say that it may not happen. I'm unaware of that.
Get rid of your record. Anything else? We may have you back. Who knows? But I think this has been very informative. I hope the committee has been able to learn and process. And what are you doing now?
I did have a question. Sorry.
Real
I'll
quick.
follow up.
Follow up.
I'll follow up.
Yeah.
Rep. Morrissey mentioned about working with Terry Corsones, and it's an absolute pleasure and to be on her team. And
Yeah, I'm looking forward to having her coming in. She'll come in and present the capital budget for you.
Let me just ask, chocolate chip?
Yeah, anything she bakes, anything she bakes.
oh, the chocolate chip are excellent. Yes, I've had them.
Crisp type thing.
She brings us treats?
She'll bring some committee streets, so yeah, she's
Brings them
terrific.
everywhere.
And me, the guy with the food industry degree, doesn't do it.
Well, here we thought you were going to make chocolate chip.
No, it's Terry. She's
Terry. She's a dear, so thank you. Thank you for coming in.
Thank you, Judge.
Thanks, Judge. That was
Sure
excellent.
we'll have you back.
Have a great day, everyone.
Thank
Thank
you.
you.
It was very helpful. So we're running a little late, so I want to continue with another issue here that deals with corrections. And if you have to take a break, personal break. But we did run a little late. We have to be on the floor at 3. And then after the floor, we do have ethics training for that. So we're going to shift gears a little bit to a previous bill that we put in place back in 21 when we were all on Zoom. Came from this committee. And then we did a little adjustment to it last session. When you folks see an act and an act number, I don't know if the new folks, I'd like a copy. I don't know if the new folks were brought through this in orientation at all. But when a bill passes. If you look at this one, if you bring this up on our webpage, or if you have a hard copy, you'll see number 56 at the top, and we've referred to this as Act 56. But what you also see in parentheses is H 435. It originated as a House bill. When that bill goes to the governor for the governor's signature to become law, it becomes an act. And then it depends on the sequence of that biennium where in the numerical order that occurred. So this was passed the first year of a biennium. So when the governor signed it, there were 55 acts, 55 bills that were signed prior to this one. And this one was the 56th. That's where you get the act number. So if it's at the second year of a biennium, your act numbers are going to be 160, 170, because they're going for the whole biennium. Then when a new biennium comes in, we start again at Act 1. So when a bill becomes law, it takes on then an act number. So I don't know if folks went through that with new folks or not. But maybe I'm redundant, but I just wanted to, because we go back and forth talking about different acts. So we have with us another legal counsel, lawyer we will be working with, Ben Nagroski. Ben works quite a bit with the judiciary committees on the House and Senate side, but he works a lot on the correctional issues. And we talked the other day, Eric brought up the Downs-Rachlin-Martin report about the sexual misconduct that was occurring in some of our correctional facilities and with some of our field service officers. As a result of that report, in 2021, we were asked by the then Commissioner of Corrections, Jim Baker, to address some of the concerns and recommendations in that report. And I wanted Ben to come in here and walk through the legislation that we've put in place to address some of those concerns. So Ben, welcome. As you can see, we have a whole new committee. A couple of familiar. So let's just go around and introduce ourselves, because some folks you may know and some may be new. So Chip.
Yeah, I'm Chip Troiano. Welcome. I represent Hardwick, Stannard, and Walden. I'm the vice chair of this committee.
Hey, Ben, Connor Casey from Montpelier. Yeah.
Hello, Ben. Gina Galfetti, representing Berrytown and a little sliver of Williamstown.
Representative Mary Morrissey.
Representative John Harrison, Weathersfield, Cavendish, Baltimore.
Just Wayne LaRush, Highgate, Franklin, Berkshire.
Close to all, but
Michelle Boslin, Westminster, Rockingham, and Brooklyn.
Hi, Eric McGuire, Rutland City.
Hello, Representative Tristan Roberts of Halifax, also Wilmington, Whitingham. Welcome.
Nice to meet all of you. My name is Ben Novogrodsky. I'm from the Office of Legislative Counsel. And I apologize if what Chair Emmons was talking about with bill designations, because if that was not gone over, that falls back on my office to give you your training.
I'm sure I was redundant, but we've been talking about a lot of different acts.
So as Chair Emmons mentioned, this is basically going to be a walkthrough of Act 56 of 2021, which was enacted as a response to the Downs-Rachlin-Martin report concerning the women's facility in Chittenden. So on a broad level, what Act 56 did was amended and created statutes related to the Department of Corrections, specifically created new sections 123 and 124 of Title 28, which created the Corrections Monitoring Commission and the Corrections Investigative Unit, respectively. It also amended 3257 of Title 13, which is the criminal statute prohibiting the sexual exploitation of people under the supervision of DOC. So it expanded what was prohibited. It also created a report requirement on minimum training standards, certification, decertification of correctional officers. And so I will go through this step by step, but being mindful of time and trying to not keep you from the House floor. So as you'll see here, Section 2 is what creates the Department of Corrections Monitoring Committee. commission. Essentially, its role is to provide advice and counsel to the commissioner regarding his responsibilities of managing the department. Specifically, it's meant to aid the commissioner's management of sexual misconduct reporting, promoting the adherence to anti-retaliation policies, ensuring overall policy implementation and effectiveness, and improving transparency, accountability, and the cultural impact of agency decisions. And finally, to ensure that the department's investigations and any resulting discipline is compliant with department policies, procedures, and directives. And you'll notice that some of the language that I mentioned now is a little different than what will be in the bill, and that's because an act last year, Act 124, clarified the monitoring commission's duties relative to the commissioner and some other issues that I'll address in time. So the commission is made up of 8 members, and they're all with restrictions on conflicts of interest. And they serve staggered terms, which are outlined in the bill as well. But those 8 members are a former judge with knowledge of the criminal justice system appointed by the Chief Justice of the Vermont Supreme Court, a retired attorney appointed by the Department of State's Attorneys and Sheriffs, a former corrections officer appointed by the Vermont State Employees Association, 2 formerly incarcerated individuals who resided at different facilities appointed by the Defender General, executive director of the Vermont Networks or their designee, former management level employee from DOC, and an individual at large with knowledge and experience of the correctional system and related topics appointed by the governor. I believe Ashley Messier is the current chair, and I'm not quite sure of her background, Chair Emmons.
I believe she was one of the formerly incarcerated individuals.
That sounds right.
I think that's what it was.
And this commission went into effect at the beginning of 2022, and there are procedures to appoint the chair, which is how Ms. Messier got appointed to that role. So as you'll see, scrolling through, subsection 2 here talks about the conflicts of interest, ensuring that there's diversity amongst the members, and really a best efforts to attain that if the population that it's drawing from doesn't necessarily meet that criteria. And then subsection C here really gets into the powers and duties of the commission. But first, I should say that the commission is temporary. It started in the beginning of 2022. It sunsets midway through 2025 on July 5th. You can find that in section 3, which is on the middle of page 6. The commission also is responsible for 2 annual reports due January 15th of this year and of next year. Those go to the DOC commissioner, the secretary of AHS, and various committees of jurisdiction, which includes all of you. That report will report on workplace improvement and progress, morale, staffing, retention, workplace conditions, and any recommendations to improve those things. So going into the powers of duty and duties of the commission.
Tell you why. There is not, I don't assume there is a report January 1st of this year.
Not that I've seen.
And I can, the commission is still in the process of trying to form itself. And there's been some internal changes that have occurred and clarification of their role. So I think that right now they're in the stages of trying to reset where they were from a year ago. That's what's happening.
Hopefully one day soon. But in going into the powers and duties, and essentially a good way to think about it is it's really a sounding board for the commissioner to ensure that they're providing advice and counsel to him in the carrying out of his responsibilities, specifically, as I mentioned before, sexual misconduct, anti-retaliation, and the policies relating to those issues. It's supposed to also examine facility staffing needs, retention, working conditions, workplace morale, which those reports again will reflect. It has the authority to engage with various employees and organizations, and this is the report requirement that you'll see in statute here. So going forward, there's also monitoring responsibilities, which was, if I could say, probably the core of the clarifications from last session. And it's just to make sure that the department is monitoring and really monitor without crossing into investigation, which is the separate unit, the investigatory unit, which I'll go into, but really about monitoring timely reporting of sexual misconduct allegations, compliance with the Prison Rape Elimination Act, which is a federal law that prescribes certain procedures and consequences for sexual abuse and things that fall under the gambit of the statute. Also the department's implementation and adherence to policies relating to misconduct and discipline, maintenance of an independent reporting hotline. And then this is where you'll see here, investigations of employee misconduct. That was changed from investigations really to monitoring again. And it was really compliance, because again, those fine-tuning those words is separating the role of the commission compared to the investigative unit. So it was really to ensure that its job was compliance with those policies and procedures and ensuring that any department response is in accordance with those policies, procedures, and directives.
Who is the investigating unit?
I'll get to that in a little bit. It's a separate unit made up of its own staff. So again, this is a reporting requirement that requires a report on these monitoring metrics at the beginning of January 1st of this year and of next year, and then that is repealed in the middle of next year based on the statute. Subsection D goes into members' terms, which are staggered terms to ensure continuity. Subsection E goes into meetings requirements, selecting the chair, what constitutes a quorum. Subsection F here is the assistance. This is something else that was amended last year by Act 124. Originally, the commission was supposed to have the technical, administrative, and legal assistance of DOC. There was fear that the legal assistance would potentially present a conflict of interest for the commission and the department itself. So that was changed now that the Attorney General's office will provide any legal assistance. Also, subsection G was amended last year as well, basically clarifying that the commissioner or his designee shall produce all relevant procedures, policies, and directives requested by the commission pursuant to its monitoring duties. Monitoring was defined last year as well, and also confidentiality protections were added related to employee or incarcerated individual records to ensure that no personally identifiable information would be disclosed, and also that only information that was relevant to the information to the incident was disclosed in a way that only revealed necessary information while preserving confidential things that are confidential as required by law, federal law, collective bargaining agreements, or employment contracts. So just sort of buttoning up any potential issues there with the change that was made last year. And these were the sunset provisions that I referred to before in section 3, the beginning date of the commission and the members when they were appointed, which was December of 2021. And these are the staggered terms that I referenced earlier. Section 5 is the Corrections Investigative Unit, which was created in section 124 of Title 28. This is essentially the investigative arm of DOC to investigate the issues that the commission is monitoring and any potential issues within it. So it's empowered to have the necessary staff to operate and carry out its duties. It's empowered to coordinate with outside investigative agencies and law enforcement concerning criminal allegations. They're also authorized to conduct personal safety planning for employees that receive personal threats. And then the employees also have various enumerated rights for their governing their interactions with the CIU. Specifically, that their rights granted under state and local law are preserved, along with any rights pursuant to collective bargaining agreements or employment contracts. It does say that information gathered in their interactions with CIU could be used in a proceeding before a court or before the Vermont Labor Relations Board. And then there's some language just ensuring that nothing in this statute will limit collective bargaining rights or of the state and employee groups concerning matters of investigations and discipline that aren't already controlled by statute. In the home stretch, the final two sections, so section 6 is what amends the criminal statute in 3257 of Title 13. And this just essentially expands the prohibition on sexual misconduct between DOC workers and people under their supervision, so incarcerated individuals. It removes a limitation that the offender be in a direct supervisory relationship with the employee. But that prohibition specifically excludes anybody that had previously been married, part of a civil union, or otherwise engaged in a consensual sexual relationship at the time of sentencing for the offense that the offender is serving in under supervision. And so that's the change there, is to remove that prohibition where there's that direct relationship. And then finally, section 7, which is what created that report between DOC and the Vermont Criminal Justice Council to create a proposal about creating minimum training standards, certification and decertification requirements, and other things related to essentially regulating the correctional position in the state. And as Chair Emmons alluded to, originally this report was due in the 2021 interim session and got pushed back to this past summer. However, the report that was submitted didn't actually make any proposals about a program. So to be determined, I suppose.
I mean, I know this isn't a question for you. Do we even know who's the commission other than the chair? Do we even know who else is on that commission?
We can get that. I know that former Chief Superior Judge Brian Grierson is on there. Executive Director of the network would be Sarah Robinson. And I'm not sure who else, because they're having a hard time forming. And I believe the chair is no longer there. I believe.
Yeah, I'm not sure.
Have they made it out?
There was a lot of confusion last year as to what their role was. And I think the thing that was really confusing and that we had to address last session was the piece about the Department of Corrections offering legal assistance to the commission. And we spent quite a bit of time on that, trying to correct all of that. So we did that at the end of the session. So we can have DOC in to really start talking about this. This was a real important commission that we put in place, and it just hasn't seemed to get off the ground. Troy, did you have your hand up just?
Yeah, is there concern that the Commissioner of Corrections is the person who's creating the CIU?
No, not really. I mean, we talked about that when we were putting the bill together, and there didn't seem to be, that I recall, Mary, Michelle, it didn't seem to be, because it's not, there is deeper investigative, if anything really happens that's criminal within our correctional system between staff and staff, or staff and offender, or offender, or offender staff, that gets into your state police. That gets into your Defender General, your Prisoner's Rights Office. It gets into that level of work. And this is kind of the first level before it hits that real criminal activity for that.
Just always wary when those investigative units are essentially the agency investigating itself.
We didn't. Ben, you weren't,
I wasn't here for that,
but that's not.
I don't know if this fully addresses your concern or not, but that is that language under sub C coordination where it says CIU shall coordinate. So it's not discretionary, it's mandatory with outside investigative agencies and law enforcement agencies concerning criminal allegations.
Right.
So there is that aspect. And then there's the requirement that they coordinate with DHR concerning, misconduct investigations and discipline. So there is mandatory coordination with outside entities, but to your point, it is still under the auspices of the commissioner.
And it's to just investigate to see if they complied with federal law and to identify systemic issues. So it's not to take action to correct it. It's just to see if the department is doing what it's supposed to be doing.
Right, and that was I think the needle that the committee was trying to thread last year is really making that distinction between the monitoring role of the commission and then the investigatory role of the CIU. And CIU doesn't really have any enforcement power per se under this. That would go to any referrals out, is how I read it. And also within any policies, procedures, and directives that the commissioner is mandated to act under as well.
Tristan and then Chip.
Would you say there's a sense that the commission is going to sunset, it's going to give its report, and, in this hypothetical of what we wrote, and then there may be additional steps at that point that the legislature may look at?
When you do a sunset, what that really triggers is a legislative review.
Yeah.
And that says, do you continue with this piece of legislation? Do you continue with this commission? Or is it really not being effective and you let it go and you do something different? That's what a sunset means. It's a time for review. Doesn't mean it totally goes away. It will go away if the legislature doesn't take any action.
Forces your hand.
Forces your hand. Chip?
So is it contemplated that this council will determine criminal liability before they make a referral?
Which one, the monitoring or the investigative unit?
The ICU, yeah.
Well, so I'm sorry, just repeat your question one more time.
So is it contemplated, for instance, that the ICU make a determination that there has been criminal activity before they make a referral to criminal justice system?
That's not explicit that they have to kind of substantiate or not.
Yeah.
I think just the way it reads is that any allegations that are criminal, they refer out. So I don't think it has to go
to make a determination. Yeah, okay.
Yeah, it's not the proper place to make a determination.
Well, that's
That
why I
would
was
be-
asking, yeah.
It could be in your criminal arena, or it could be in your Department of Human Resources, the State Department
Yep.
of Human Resources, when it gets to personnel issues.
Okay.
We're just
Thank you.
trying, this was a way of really having an investigative unit within the department to follow along, to make sure the department's complying with federal laws, and that if they're seeing some systemic issues where there's allegations of violations of the PREA Act or major events in the department, that there is some look-see in this, and if they have to forward this to the criminal investigation or to HR, then they could do that. Because in the past, things were happening and nothing was getting forwarded.
And many of these recommendations were recommended in the Downs-Racklin Martin report itself. So it was just taking a lot of the structure that they suggested and putting pen to paper.
The other thing that we did, also that we looked at, and it was controversial with the VSEA, there was another, well, they were concerned, the VSEA was really concerned about the Criminal Justice Council doing a report on minimum training standards, compliant investigations, and a process for certification and decertification. The VSEA was really concerned about that, particularly the certification and decertification of correctional officers. We don't have any of that in place currently. The thinking was to really bring a level of professionalism to our correctional officers' positions, that there is a feeling of, yes, this is a professional job, and we have a place to grow and go up the ladder, and to start professionalizing and respecting that position. And the way to address that was starting to look at their training standards, and do we put in a process of certifying and decertifying correctional officers to really say, hey, you mean something here, and this job means something, you're important to the system, and let's professionalize this system. That's why we had that report. We did get some pushback from VSCA, particularly on the certification, decertification, to look at that. We have not received a report back on that. The part of what we heard in Justice Oversight was pandemic had an impact on the council. The council's been asked to bring on a lot of initiatives to carry through, and they've been overloaded with that. And then you added this to it, was just adding more workload. They've gone through some transition on the council. And also in looking at the certification and decertification process, if they look at the way it's done for law enforcement, it just doesn't transfer easily to correctional officers, and they were having trouble with that one.
Yeah, and if I recall correctly from the Justice Oversight testimony this summer, I think on that issue specifically, it was, part of that is the way our correctional system is structured. We have one unified system in Vermont as opposed to New York, which is very
Separate entity.
Yeah, separate, thank you.
Yeah.
And because of that, and in comparison to how you look at our police departments, which our municipalities have them, our state police, our sheriff departments, very separate. And so there isn't that nice fit, but also, I think it was, and this may have been Commissioner Demmel that testified to this, is that if there is discipline for a correctional officer, it's not like they can go to another county and their correctional system in the state and that discipline wouldn't be found. I mean, it's essentially, it's a statewide discipline at that point within the correctional system because it's unified. So I think that's an important point for the committee to be aware of as far as some of the reasons that the department and other stakeholders explained as to why it wasn't necessarily a good fit, at least in this is the way that the JC is structured.
In other states, your correctional system is under the Department of Public Safety, so they can be considered law enforcement to begin with. We don't do that because we don't want them to be wardens and guards, the correctional officers and superintendents. The other thing we looked at, and we initially had it in the bill as it passed out of our committee here, it got changed as it was going through the process. And the VSCA wasn't really supportive of this either, was body cameras. We wanted body cams for the correctional officers. And the money was in Appropriations Committee. We put the language in here, and we wanted to make sure that the body cams would not be in place until the protocols and procedures were put in place for the usage of the body cams. So as it worked through the Senate, that language got put into the appropriations bill with the money. So last year, maybe it was the summer before, it was probably the 21, and through the fall of 21, DOC worked on the protocols and procedures for the use of body cams. And I believe now that they are in place, the body cams are in place at this point, I believe, but you don't know. Because I know that they had it the policy was pretty much in place towards the end of 21, beginning of 22, during last session.
I just don't know what the implementation is.
Yeah, so that's something we can pick up. But the reason for that is there's a lot of allegations that happen on all sides. And if we can verify what actually happened, it will support our officers, it will support our offenders.
Right.
Because there can be allegations between offenders, there can be allegations offender to staff, staff to staff, or staff to offenders. And that was the thinking, but we really wanted a protocol and procedures in place as to the use of those body cams and the data of that. So that's just another piece that was here. Wayne?
So VSA, do you, just generally, what was the objection by the VSCA to that?
To the body cams? Mary's not here. Michelle, it was
I
more,
feel like it was sort of a civil rights thing.
Yeah.
Like they said, oh, well, how, it's not even for the people who are incarcerated, like you're violating their privacy because you're constantly, like everything you say is gonna be under this monitoring. And it was, I think for both their staff and for the individuals that were incarcerated, they just said it's too invasive. And you don't like that. I
it
think it
felt
was
that we didn't trust them too, it just kind of felt like, well, you don't believe our words. And, it was, we just wanted clarity. And that's why there was also a proposal as it initially came in that this committee did not, I don't think we agreed to this, was doing some lie detecting testing for folks who are just applying for correctional officers to do some of that. That never got through.
I think that got struck from
It got
Act
struck.
56.
Yeah.
Yeah, if you look at the top of the bill, you'll see Section 1.
Hey, Connor?
Was there a big appropriation tied to the body cameras? I would think that'd
Yeah,
get
there
pretty
was.
expensive, with the
Yeah,
storage and everything too.
Yeah, I forgot what it was, but that money was linked to having the policies and procedures in place.
Gotcha.
So it all ended up in the big bill appropriations, because it did come in as the governors recommend in the budget, but they didn't have any language. So we worked up the language, and we did have the language in this bill as well, and passed. So, I mean, this committee has done a lot of work over the last many years in terms of correctional policies. You heard about it just a little bit today on the pretrial services. You're hearing it about this. You've heard a lot about it for JR2, Justice Reinvestment 2. We've done a lot of work over a lot of years in terms of addressing correctional issues. Has it all been right? We don't know. We put in home detention, we put in home confinement. We have a home confinement statute that if you're incarcerated, you're sentenced, you can serve some of your sentence under home confinement status. It's a furlough status. In good time, we did earn good time. We've put in now presumptive parole, which we're going to get the parole board in.
Discussion of presumptive probation.
Yep, and we did midpoint review for someone who's on probation, a term probation, midpoint review to see if you're really doing well. Maybe you can come off of probation at that point so that you don't have to do your full probation. We've done that.
Appeals of revocations and suspensions too, kind of streamlining those processes to try and make them speedier.
Yeah. So we've put in a tremendous amount of initiatives to support our folks who are incarcerated that are reentering the community and want to be supportive, try to stop the churn in and out of our doors in the correctional facility.
Chairmans are basically just listing my portfolio of subject area in the judiciary. So we're going to talk about a churn,
Go through these two doors. So there's always work to be done, but I think it's important to understand the work that has been done and what's in statute. Now, maybe some of those things in statute aren't being carried out, like the monitoring commission. I think that would be good to have DOC in to talk to us about that. I think it would be good for them to come in and talk about the investigative units, about that. And Mary, did you have your hand up? Nope. But Mary's been through this with us. We put a lot of corrections initiatives in place. We worked in terms of the medical piece with if someone's coming in with a prescription for a certain medication, they continue on that when they're incarcerated. We established the MAT program in there. For that all came out of this committee.
So redefining technical violations as opposed to new crimes.
New crimes, so that it helps. If you have a technical violation, doesn't necessarily mean you're going to go back into a correctional bed. Let's deal with it in the community. Okay.
I assume that the correctional system has a training program for their officers coming in.
They do. They have an academy that's run through DOC. It is up in St. Johnsbury, I believe.
Yeah.
And we have required over the years, mental health training be done for our correctional officers. We've done social equity, racial equity training be done. We did that 2-3 years ago for that. But it is run by DOC. Okay. And Tristan, do you have your hand up or your finger?
I did. Thank you, Madam Chair. Is this question of certification or minimum training standards? We ordered something, it hasn't taken place, but we do require people to go to this academy. It's sort of is there a minimum standard to be a CO? What is it?
Well, it goes in classification as you need a high school diploma.
You have to pass their training.
Their training.
What's the?
It's a 6-week course. We can have the director, I think his name is Jim Rice. We can have him come in.
And you transfer here from New York, you go through the training course, so everyone goes through the course?
Yeah, the question that was put before us from Commissioner Baker at the time And this, I think, can fall two ways. But one thing he did put on the table to think about is when there's a new recruit coming in, there's a different culture in each of our correctional facilities. There's a different culture. Whether you like that or not, or agree with it or not, there was a different culture. And what he was saying is when the department hires a recruit, they go into the facility to work for, I don't know, a period of time. I don't know if it's a couple months or whatever, prior to going into the academy. And what he was seeing was with that time that they're spending in that facility, they pick up the culture of that facility and they bring it with them to the academy. And he was suggesting when you bring on a new hire, you bring them right into the academy so that they don't get that tainted, if you want to say. I say that reluctantly, but you know, that you don't pick up the culture that's in whatever facility and then they go back to that facility. So we never did that. But that was one thing he put on the table for that, and it might be something worth talking about. I don't know. I don't know.
So that training doesn't happen upfront, like you're saying, they don't, as they come in as a new hire, they don't immediately go to training. So it's not like the police at all. Where
Right.
They have to go to academy and sometimes have to have, you know, like for the game wardens, they have to spend a year in the field with another warden working. And state police not so long, but same kind of.
So that's what he was indicating. I don't know if they've changed anything at this point, but they would come in and work in a facility for a time before they go to the academy. And that tends to give some of them a certain perspective, and then that's hard to do that. So I don't know. I don't know how true that is, but that was put on the table for us for that. So there's lots of layers. Anything else? So if folks have some thoughts in terms of what you'd like for testimony on some of this, you know, let me know, let Chip know, let Phil know, because when we do scheduling. But I think it would be good to get folks from DOC on the academy piece to come in. I think it would be good to reach out about the monitoring commission and the investigative unit. It might be good for Ben, for you to come back at some point, talk to us about earned time.
I could do, I did a review for Senate Judiciary on sort of justice reinvestment related initiatives, so
That would be.
furlough, probation, things like that, so I could do something similar.
Why don't we do that? See if you could schedule some of that. I don't know if we have time next week or work with Phil. So we're on the floor at 3:00 and then we have the ethics. We stay right on the floor. So we're back